Thank you all for coming. So the title of the paper is The Questionable Origins of the Copyright Infringement Analysis. And what I tried doing in the paper is to examine what exactly motivated the thinking of Gerald Frank when he crafted the infamous, or famous, depending on your perspective, Arnstein versus Porter analysis, which continues to plague, haunt, or influence, if you're mildly agnostic, copyright infringement analysis across the country. It is a historical exegesis that is based on a review of the Gerald Frank papers, and as I went into the archive to try and understand what exactly went into this case, I was really surprised, but particularly intrigued when read in against the backdrop of Gerald Frank's own legal philosophy that by 1946 he had developed very, very well. So a little bit of background. Now let me say at the very outset, there's a lot of factual information in the paper, and I'm going to try and run through it rather rapidly. I'm hoping that I'll leave some time for Q&A, but I might have to gloss over certain things. There's a full draft available on the website, and I'd be happy for any comments, questions offline after. Okay. Arnstein versus Porter, as everyone knows in the copyright context, is this canonical case that every copyright casebook starts with, which discusses the copyright infringement analysis. It's taken to have crystallized the analysis, even though it may have begun earlier. The infringement analysis in Arnstein versus Porter is entirely judge-made. It is not a derivative of any particular statutory perspective, and it was crafted by Judge Gerald Frank in this 1946 case. Most circuits around the country follow this standard, the Arnstein analysis, in one form or the other, which basically has a bifurcated step one, step two. Step one basically is an examination of whether there was actual copying. It's an epistemic reconstruction of the fact. You can use direct and circumstantial evidence, extrinsic or external expert testimony is allowed, as is analytic dissection, and it is treated as a question of fact. That's step one. Step two is the real intriguing one, which is the question, all right, even if there was copying, was it quantitatively and qualitatively sufficient that it should be deemed improper or wrongful or illicit to be deemed an infringement? For this, the Arnstein test, and as has been followed, says that you adopt the lay listener standard. It's meant to be a subjective or intuitive response of the lay listener, not so much a whole analysis, which is to say that expert testimony is actively disallowed. Very intriguingly, and this is the core point in the paper, this is treated as a question of fact and is meant to be handed over to a jury. So here's the puzzle that I'm seeking to solve, or at least attempted to solve when I started writing the paper. Arnstein is therefore based entirely on a jury-focused approach. The idea is that the jury should do as much as possible in the analysis, especially the improper appropriation prong. Why? Arnstein itself, the opinion doesn't give us a full explanation for this. What makes it even more intriguing is that Judge Gerald Frank, over the course of his professional career, starting in 1930 right up until 1945, and in his non-judicial writing, basically attacked the jury system in 3 separate books. Right? Law in the Modern Mind, Courts on Trial, and If Men Were Angels. He basically had a certain amount of disdain for the jury system. So why, in the construction of this case, did he adopt a very different approach? So I decided to go into the Gerald Frank papers to try and understand, and the background behind it was particularly intriguing, and there was a lot of intrigue, as I will try and show. So the story begins a few years before the actual Arnstein versus Porter case. Ira Arnstein is a peddler of short melodies in New York, not very successful. And starting in the 1940s, he starts suing a whole bunch of different composers on Tin Pan Alley, claiming that they had plagiarized his work. All of his 4 prior lawsuits by the time of Arnstein versus Porter fail, because he has no proof of copying. And by 1945, he decides to target the famed composer Cole Porter. He appears pro se, which is very, very important. So he has no legal strategy that was externally dictated. The legal strategy in Arnstein was Ira Arnstein's. And he seeks damages of $1 million in his lawsuit. So in the lower court proceedings, well, initially depositions are taken. Arnstein deposes Cole Porter. Porter's lawyers, thankfully, depose Arnstein, but that doesn't seem to have any other effect, other than Arnstein continuing to assert that Cole Porter did plagiarize from his work. When asked to offer proof of it, he simply says, well, you know, I have a feeling that he hired stooges who followed me, lived in my apartment with me, ransacked them, and Cole Porter's lawyer asked him, do you have any proof of this? No, I have no proof, but I have no proof to the contrary. And that's enough. And so on the basis of this, Cole Porter's lawyers file a motion for summary judgment, The district court judge, Judge Caffey, grants it. He characterizes Arnstein's case as a fantastical story, and he says there's just no proof here, I'm going to get rid of it, but he introduces a last paragraph which seems to rub Frank the wrong way. And if you look at the opinion, he says, well, I'm not going to waste my time going over Arnstein's other arguments, because he's filed far too many cases. I have a very, very heavy workload. He actually puts this in the opinion. I have a very, very heavy workload. I better turn to the rest of my docket. Now, Arnstein appeals. Now, here's the thing to note. At this time in history, between 1920, 1925 and 1945, a lot of historians, legal historians, claim that the Second Circuit was indeed the most prominent court in the country. Why? It had a whole bunch of New Deal judges who had been appointed. They were prominent academics, prominent jurists, and the Supreme Court at this stage didn't have the real personalities that the Second Circuit had at this point in time. As luck would have it, the Arnstein appeal lands before a very, very powerful panel, which in some ways dictates what we have in the copyright infringement analysis. So the person who authors the majority opinion is Gerald Frank, an exceptionally smart, bright, witty, and punchy jurist, who by the time he was elevated to the bench was a legal superstar because of having written one of the best-selling legal books, Law in the Modern Mind, graduate of the University of Chicago, highest ever recorded GPA. He took that to heart. He thought he was the smartest man in the room during any conversation. But also on the panel was none other than Learned Hand. And Learned Hand had written some of the most important copyright law opinions by this time. He had effectively crafted the copyright infringement standard. Think Nichols and a whole series of other opinions. He was on the panel but did not write the opinion. The third judge was Charles Clark. Now Charles Clark, and I didn't know this until I talked to some of my colleagues in civil procedure, is a legend in civil procedure. A professor of civil procedure, dean of the Yale Law School, became Sterling Professor, and before being elevated to the Second Circuit, his biggest claim to fame was that he was a principal architect of the Federal Rules of Civil Procedure. In particular, his professional baby was Rule 56, that he felt responsible for. Now, so the panel has these three people, and Gerald Frank, by this time, however, has developed a fairly intriguing but unique and outlying legal philosophy that he's pushing around the country. He was one of the early founders of legal realism, very close friends with Carl Llewellyn, but he's so extreme that even Carl Llewellyn distances himself from Gerald Frank. So in his book, Law in the Modern Mind, he kind of develops his whole thesis. He calls it the basic myth of the legal system, and there are three core ideas that he develops in the entirety of his extensive body of legal writing over a course of about 15 or so years. And to summarize the three ideas, they are, one, the recognition that legal rules are never a constraint. Right? This is the core philosophy of legal realism. Rules are intrinsically manipulable, that basically you can have a rule for just about any outcome you seek to derive. It is not a constraint. The second and the third ones are more important for our purposes. The second one, it was Frank's belief that it was hunches that actually result in decision, not law, not logic. And what did he mean by a hunch? And he actually took this from Judge Hutchinson. The idea was a decision maker's subjective reaction to a particular set of facts. He said the judge decides based on the hunch and then rationalizes backwards to come up with some reasoning in order to explain the hunch. But the decision is made by the hunch, which is an intuitive, subjective reaction to some aspect of the case. And if you read Law in the Modern Mind, it's kind of ridiculous, the kind of facts that he provides that might generate the hunch. He says the hair of a particular jury member could be the basis of the hunch. And so he actually believes that all judges are biased in some way or the other. And we'll get to that in a minute. The third prong, which was his driving legal philosophy, is something he calls fact skepticism. Unlike the other legal realists who were rule skeptics, Frank was a fact skeptic. What he meant by that was that rules and rights don't exist. They are myths. Because everything that we have in the legal system is heavily dependent on fact finding. And since facts are intrinsically subjective, the whole legal system is subjective, and it is a myth to talk about rules and principles, even insofar as you may be skeptical about them. So focus on the fact-finding process, and since facts are subjective guesses, recognize the reality that this whole legal system is premised on subjective analyses. Lower courts, he believed, and this is the driving aspect of his legal philosophy, were deluded. They were not malicious. They were deluded, and and came to recognize that the fact-finding process was extremely subjective and they could do whatever they wanted with it. And over a period of time, they were influenced by certain unconscious and subconscious biases. Now there's a little bit of history about why Frank got into this. For 5 years, when he moved to New York from Chicago, he subjected himself to psychoanalysis and then went around the federal judiciary trying to tell every other judge to get into psychoanalysis. That is the range, right? Okay, so, but the consequence of his extreme fact skepticism is that he truly hated summary judgment, right? Because it placed far too much power with the lower courts, who we believe were deluded. Okay, now you can see where this is leading. So I told you about Hand, the greatest judge who many believe to have never served on the Supreme Court. Many claim, including Gerald Gunther, that he was the greatest copyright judge. It's not clear whether he was the greatest, but certainly one of the great copyright judges in terms of what he constructed. I told you about Clark and his love for Rule 56. Well, there's another important aspect which is really pivotal in this case. Frank and Clark, and I cannot overemphasize this, absolutely loathed each other. And this hatred was professional, but it had a distinctive ad hominem dimension. It was very, very well known. Felix Frankfurter, once at dinner, told Charles Clark to be nicer to Frank. Okay? That's how well this was known. They disagreed about just about everything. They were on the same panel in about 200 appeals. On 58 of them, one of them wrote a dissent. Okay? And it just, even if there was a concurrence, there had to be a dissent on some issue. And you see that all the time, especially in the copyright opinions. Hand and others would take and make this acrimony public in one of the actual memoranda. In a related case, you actually see Hand saying, when the two of you stop shouting at each other, for God's sake, please, please file the opinions. That's what we're here for. All right, so it's unclear. Many have tried to speculate what the basis of this disagreement was. It could well be that these were just two towering personalities, but that had an enormous influence on the case of Arnstein versus Porter. Here's a little bit of a factoid which is important to note and why we have this rich historical record. The Second Circuit at this point in time has a very intriguing practice, which is that for one whole week from oral argument, the judges will not meet. They were precluded from meeting in conference to decide the case. They were only allowed to exchange their views by written memoranda and would have their conference a week later, by which time they were meant to have indicated how they would vote. Well, this means, again, it's close for us, there's this rich historical record of a paper trail that you can see how they were actually trying to persuade each other and what their thinking was and how they changed their views, but they hated it at the time, especially the slower writers like Clark. And you'll see, Frank had a clear advantage. So within 3 days of the oral argument, Frank fires off his first memo to both the other judges. And he says, well, I've listened to the musical compositions. There's a marked resemblance. And guess what? So does my secretary. I don't know anything about music, but my secretary knows enough, and I'm pretty sure, therefore, that I want to reverse. And then he's also sympathetic right through his first memo to Arnstein. He says, look, Newton was a little bit of a crazy person, but he was a genius. Sometimes geniuses come in different shapes and sizes. Let's not jeer this fellow out of court just because he appears a little touched. Okay? So at this point, the first memo, no reference to summary judgment, no reference to copyright law. And he worries that Judge Caffey hadn't given Arnstein a fair hearing because of his past litigation record that Caffey had in the district court characterized as vexatious. Well, Clark responds 2 days later saying, I was down in New Haven where he lived and I met my good friend, Professor Luther Noss, who's a musicologist. And we decided to spend the evening over whiskey actually playing all of the tunes. And Noss convinced me that Arnstein's claims are fantastical, because they were all a repetition of the high E. And therefore, if you listened to me, you would be convinced too. Well, Clark didn't just stop there. Clark also said, well, I'm also very upset with the Second Circuit's increasing trend to reverse summary judgment. And very important, up until this point, Frank had not made the case about summary judgment. Clark, in pushing him to say, and guess what, I'm protecting summary judgment, gave Frank additional fodder for the next memo. Frank was offended, deeply offended. Why? Because he believes that Clark was taking a dig at his view on summary judgment. So Frank says, well, we don't all believe in your enlightened view, which is infectious, of civil procedure. And he disagrees with him, and this is one of Frank's short memos. But in his personal version in the actual archives, Frank, in pencil, scribbles in, and he has his initials next to it, scribbles in some thoughts that he never puts into the memo. He's constructing, at least this is my reading, what would eventually become the Arnstein standard for weighing access and similarity on the first prong, almost anticipating what Clark's response is going to be. Never makes it into the memo, but he puts this in there. So Frank fires this off, calling Clark an enlightened soul in civil procedure. Well, guess what? Clark is also offended. Now Clark decides to take the argument in a distinctively ad hominem direction. He accuses Frank of sidestepping the musical issue altogether and says, you're trying to actually avoid appellate courts doing work, you don't understand what's going on, you're overstepping your boundaries, let's come back to the musical issue. But Frank never returns to the musical issue. After the first memo, it's important to recognize, after that, Frank and Clark never once managed to fully articulate their disagreement on the musical issue itself. Well, Frank, again, within 4 hours, fires off another 4-page memo, accuses Clark this time of secretly calling in an expert, which is Luther Nuss, saying this is improper, you're violating all codes of ethics, and that this irregularity was worse than the backbone you think that the Second Circuit would not exhibit if it did not allow summary judgment. Okay? Now, very importantly, up until this point, Learned Hand is just sitting there and watching these two people go back and forth. Right? They have written 6 memos, a total of about 40 pages by now, and Hand hasn't even said anything. So Hand finally weighs in, saying, right, this case really, really troubled me a lot. I initially assigned it to myself, but when I woke up and I saw your memos, I decided to give it over to Frank. And what is his logic? Well, his logic is, I listen to the music and I think there is some resemblance, but I have no doubt that the jury will not find any copying. Our country loves litigation, and we therefore need to let this go forward to let the black arts be realized in the district courts. He actually says that. That's what Hand actually says, and he sides with Frank. Okay, so what's actually going on here? Now, the two of them never quite give up for the rest of their life on Arnstein. In some other exchange, Clark tells Frank that, oh, you really liked Arnstein and therefore you chose to find for Arnstein. And Frank goes off the deep end and fires off 2 8-page memos to Clark, now ex post, describing what he thought he was achieving. So the first thing he admits in this memo is that he was heavily motivated by the musical hunch, and that he wanted the jury to test the little bit of musical resemblance that he thought he found when he listened to it. He admits that this was the hunch that he was sending back to the jury. But very important, let's just put this in the context of Frank's overall theory of hunches. Frank does not think that hunches are bad things. Frank believes that hunches are good things as long as you don't try to rationalize it, as long as you don't try to fudge it ex post. And that explains why he's willing to have the hunch tested by the jury and not the judge. Well, a little bit more about the exchange. So Clark says, all right, what about the 2-step copy? Where did you pull that out of? Which hat? And to that, Frank says, well, let me start with 2 things. One, Learned Hand was on the memo, was on the opinion. I hope you recognize, Clark, that this was as much his opinion as it was mine. So your critique of him is as much, your opinion of the opinion is as much a critique of Hand. And he made copyright law, right? So he hides behind Hand's copyright expertise, and then he puts together a 6-page memo trying to articulate all the prior cases that he claims to have relied on. And this is one of the worst pieces of legal writing that I have seen, because he cites cases for propositions that just don't exist in the case itself. He doesn't understand the basic structure. For example, he cites Folsom versus Marsh for a completely irrelevant point. And Charles Clark sees right through this. He says, the cases you cite show hard you must grub for not even a faint suggestion of what you have done. And the hypocrisy is revealed 5 days later. And this is something which I don't know why we don't teach to reveal the hypocrisy of Arnstein. In the Federal Reporters, the next case after Arnstein is Heim versus Universal, a case on substantial similarity, where Frank is willing to get rid of the jury and decide on summary judgment. Right? And Clark goes off the deep end. Even though he agrees in the result, he writes a dissent, saying, I have no idea what just happened here. They're so musically astonishing, I just am not sure what's going on. Okay, so what was Frank really doing, putting all of this together? What you see from the facts of the case, very importantly, the Judge Caffey had come to his decision on the factual question of access. Improper appropriation was not even an issue in the lower court. So Frank could have just decided it based on his disagreement with the fact and sent it back. But he runs the risk, in so doing, that the lower court would have granted summary judgment on the second question, on improper appropriation, which is a real black box. So what he has to do is bifurcate the two, treat improper appropriation as a jury question, club it together with the question of probative similarity, and then make the radical claim that there's enough such that for this particular case, it needs to go before a jury on both prongs. Right? So what he's trying to do is effectively put in place his philosophy of deep fact skepticism, the recognition that trial courts, if you did let them do the fact-finding process, would fudge the facts to come to whatever conclusion they wanted. He needed to, therefore, come up with a mechanism that would take the entire logic of the copyright infringement analysis away from the judge, both for this case, but he had it in his philosophy. And if you go back 20 years before to the Harvard Law Review article that he wrote titled "Say It With Music," what Frank actually says is there are some decisions that you cannot reason and analyze, that are intuitive, and one of them is musical. Do not try and analyze it, it's an intuitive decision. What he's trying to do here, effectively, putting all of that together, in which he cites, is getting rid of any possibility of expert testimony on the second prong. Now, this has two possible rationales, both of which connect to each other. One is obviously the recognition that you want it to be an intuitive judgment, that is not reasoned. But secondly, with the Arnstein case, he knew that the moment you bring in an expert, and he was under no illusion, based on what Noss had said, and Noss had talked to his entire faculty, based on what Noss had said, that if you bring in an expert, there is no way this gets past summary judgment. And the elimination of Noss was therefore a critical component. Sorry, I have 4 more seconds. Basically, Arnstein was constructed in the image of Frank's fact skepticism, and we still live with it, despite the fact that this dystopian view of lower court judging has since come to be eliminated in the years since. Thank you. I'm very happy to take questions.